So what is space policy to start with, and how does it interact with regulation or space law, as some people may want to describe it? And which comes first? Do we set the policy first and then try to implement some regulations, or which one comes after the other? We always have this chicken and egg story, about which one came first. Is it the policy or the regulation? And so hopefully today we will be able to throw some light on this and hopefully share some knowledge between ourselves. So policy, if you look closely, it's basically the political decision-making process and the application of public policy of a state or a group of states regarding the conduct of space flight and the conduct of space activities, the utilization, exploration, and use of outer space. And this includes both civil or commercial uses as well as military uses of outer space. Now, in that, and this definition you will find on the web if you Google space policy. I'm sure this is the first thing that will pop up. But within that scope of activities, you see that there's a broad range of issues that we're dealing with. Number one, you're talking about access to and use of space. And, under what circumstances can a state or an individual access outer space and, space flight? What purposes can space be put to? And so forth and so on. So you clearly see that space policy will interact with defense policy, for example, because you're talking about military uses of outer space. We've all heard about spy satellites. We've all heard about anti-satellite weapons, popularly known as ASATs, and so forth and so on. Space policy will also interact very largely with science policy, because much of what goes on in space is powered by science and innovation, and therefore you can't take one away from the other. But above all, and here's the chicken and egg story, because of a number of issues that we faced in the past, it is important, extremely important, that space policy, be it national or international space policy, is governed by international law. Now, the reason why I say that this is important is that, as we all know, outer space is known as the part of the global commons, right? No state or no individual can claim ownership of outer space. No state can claim sovereignty in outer space, unlike, our national territory or the airspace of our national territory. Outer space is not subject to national sovereignty or appropriation by any means. And you need to have a legal regime in place to ensure that this status is protected and that, states are able to have the freedom to operate in outer space, irrespective of their circumstances. And so you will all be familiar, if not today, at least you will come out of the seminar or this webinar knowing about the Outer Space Treaty, which was adopted in 1967, and which sets the basic legal principles, international legal principles, governing the exploration and use of outer space. So I will not go into details into the treaty, but of interest to us is the fact that the treaty sets out the principle of the common interest of mankind in space, which is the fundamental element to show that outer space is not subject to appropriation or ownership by any one person or any one state. There's also the principle of freedom of exploration and use. I've also mentioned a number of times already the prohibition on national appropriation of outer space. There's the principle of peaceful purposes, the use of outer space for peaceful purposes, which is enshrined in the Outer Space Treaty. And to make all these implementable, or to bring some enforcement to this, there is the principle of responsibility and liability also enshrined in the Outer Space Treaty. And so if you read the treaty, you will find out that an appropriate state is required to authorize and continually supervise all activities that are carried out by entities that, from its territory, from its, so by that means, you would have then the intersection between, policy and then regulation, because through the concept of the appropriate state and responsibility, states then must now lay down regulations through which they're able to control and manage or govern the activities carried out by their subjects in outer space. So from there, you go into the element of national regulation of space activities, and you will find out that in different countries, there are different laws depending on the different types of activities that are happening from those states in outer space. So that provides the domestic basis for space law to be enacted and to be implemented and to facilitate the conduct of space activities. Now, where does the regional entities, such as the African Union, come in? When I first described what space policy may be defined as, I mentioned an association or a group of states. Nothing prevents a group of states from coming together to share a common aspiration in the exploration and use of space. And so today we will have Dr. Mahama, who will tell us all about the African Union policy and strategy on space, which represents all the 55 member states of the African Union. And so we would see the continental initiatives that are being undertaken to ensure that, we are not left behind, Africa as a continent. And then moving forward, in the next session, you would see how these policies and strategies are actually being unpackaged and implemented at the national level. So without taking too much time and without trying to take the wind out of everybody's sail who will speak after me, I will end with this brief introduction.